as friends. Obiter Dicta. So, Obiter Dicta is different from ratio decidendi, which is a principle deducible. It is a ratio decidendi is a rule, principle deducible from its application of law to the facts and circumstances of the case. But then, what is Obiter Dicta means? Which is other than ratio decidendi. And in the words of the Supreme Court, already I told that the landmark judgment regarding this ratio decidendi and Obiter Dicta is M.R. Apparao case. Supreme Court defined Obiter Dicta in that case. According to it, it is distinguished from ratio decidendi is an observation. So it is a Obiter Dicta is an observation by court on a legal question suggested in a case before it, but not arising in such a manner as to require a decision. It may be also a legal question, observation regarding a legal question suggested in the case, not required to give a decision. So that is called Obiter Dicta. Such an arbiter may not having binding value, binding precedent, because it is not the observation. Otherwise, it is an observation which was unnecessary for the decision pronounced. So, when unnecessary or not necessary to decide the question before it, any legal observation is done, it is arbiter according to the judgment. It may have some persuasive value, but not binding precedent. That also has given in this judgment. In other words, it is a chance remark, maybe basing on the reputation of the judge or eminence of the judge, or the facts and circumstances in which the observation has been made. Basing on such circumstances, it may be taken, it may be give more value or value, but it is not binding. So this is about Obiter Dicta. So now clear. What clear? What is stare decisis? What is doctrine of precedent? What is ratio decidendi? What is Article 141? Which judgment binds? To some extent, we have discussed. Now, what are the exceptions? That means which judgments not binding? Which judgments are not binding on the courts in Indian territory? Otherwise, exceptions. You take first per incuriam judgment, sub silentio judgment, judgment made with concession, judgment made with consent, or mere observation, or mere discussion, and which judgment made without any discussion or without considering any legal aspects. These are some judgments dismissed in limine. Some of the judgments which are not to be treated as precedent. Okay, come to per incuriam. The literal meaning of the per incuriam is carelessness or ignoration. Means what? Ignorance of the law. Ignoration, ignorance of the law. So, you take the judgment of Municipal Corporation of Delhi versus Gurnam Kaur of the Supreme Court. It says these are exceptions to the doctrine of precedents, and also define what is per incuriam. According to it, what says? The quotable law is avoided and ignored if it is rendered in ignoration of a statute or other binding authority. So, if the court gives decision by ignoring the previous decision which is binding of the court, and are ignoring some binding statutory authority or some authority, if it gives such a decision, it is called per incuria. So, if you take the example of per incuria, Siddhartha Satlingappa case regarding 438 anticipatory bail. In that case, a High Court has given a judgment without following CBS Constitution Bench judgment. That means Constitution Bench has, in a CBS case, has given some guidelines. Without following that guidelines, following some other judgments of which are not rendered by Constitution Bench, which are rendered by smaller quorums, judges bench with a smaller quorum like 2 and 3. You know that Constitution Bench minimum should have 5 judges. So by basing on other judgments, other than Constitution Bench, when High Court has given a judgment, it was challenged before the Supreme Court, and Supreme Court held that because of not following the judgment in CBR, that judgment is not valid and set aside. So this is one example. So this is per incuria. And in 2015, in either consultancy judgment, Supreme Court has given a detailed meaning for per incurium judgment. A decision can be said to be given per incurium when the court of record has acted in ignorance of any previous decision of its own, or a subordinate court has acted in ignorance of a decision of the court of record. As regards the judgment of this court rendered per incurium, it cannot be said that this court has declared the law on a given subject matter if the relevant law was not duly considered by this court in its decision. So, court of record has acted in ignorance by ignoring this previous decision of its own. If any subordinate court acted or this court of record acted, then it is called. That means court of record also is binding to follow the previous decision. Of course, regarding that, some other matters will come, like the quorum of the bench, whether it is Constitution Bench or whether it is bench consisting with 3 judges or 2 judges. All these things come within the court of record. Regarding other courts, suppose High Court and other subordinate have to follow the court of the judgment of the Supreme Court. Within Supreme Court, they have to follow the previous judgment subject to the conditions. If they want to differ, they can differ by following an appropriate method. It is another chapter, we will come to that. So, this is regarding per incurium. Next, come to the per incurium. The best judgment is Young versus Bristol Aeroplane Company Limited, 1944 judgment. Okay. Then come to sub silentio, the another exception for doctrine of Precedent. This also we can see the observation in Supreme Court State of UP versus Synthetics and Chemicals Limited, wherein it is held that sub silentio is an exception. According to Salmond on jurisprudence, what is sub silentio? Sub silentio means when the particular point of law involved in the decision is not perceived by the court or presented to its mind. So, without applying its mind, without taking care of the law applicable to the facts of the circumstances case, without any discussion of arriving at a reason or arriving at conclusion, without discussing any reasons, if any judgment rendered, it is called sub silence. Sub silence means in silence, without express words. So, in the absence of any reason, in the absence of any application of law, in the absence of any application of mind, just because it is a court, if it rendered such a decision, it is called sub silentio. It is an exception. So, if you take Municipal Corporation of Delhi and Gurnam care, the court observed like this regarding sub silentio. According to that, a decision which is not express and is not founded on reasons, nor it proceeds on consideration of issue. So, which is not express, is not founded on reasons, nor it proceeds on consideration of issue, then it cannot be deemed to be a law declared to have a binding effect as is contemplated by Article 141. Not express, not consideration of issue, not founded on reasons. If such situation is there, it cannot be. Next, in Lancaster Motor Company Limited case, it explained the sub silentio like this. It was passed without proper deliberation and without argument, without reference to the crucial words of the rule and any citation of authority. Then it is called sub silentio. So, this is about sub silentio. Next, there are other exceptions to the doctrine of precedent. That is, you take concession. Suppose if any judgment made with concession, I already told what is concession. Suppose any party to the dispute waived off their rights, or any party to the dispute waived off some portion of their right, or has agreed for something to lose, but then if such judgment is not binding, it is not a precedent. In other way, judgment made with consent also is not a precedent. It is because there is no analysis of law, because there is no laid down of any rule, application of any principle. So it is not a binding. And such other situations, suppose SLP dismissed in limine, that means without speaking order, without going into merits. It is not a hurdle to the party to approach High Court. This is not binding precedent. So these are some circumstances. And other issue is there. Suppose Supreme Court passed a judgment, taken a decision by observing that it should not be treated as precedent. Then what is the fate of such judgment? Normally, it should not be treated as precedent because that observation is there. But there are different of opinions regarding this type of judgments. You take in Mumbai High Court held regarding this type of judgment, which is ended with this rider that it should not be taken as a precedent. Though that observation is there in the Supreme Court judgment, it binds on the courts, because Supreme Court has no such power through Article 141. 141 has not made any proviso by giving such power to Supreme Court. So, once a judgment is rendered, by discuss the merits of the case, by discuss the law, and by applying its mind, by laying down a ratio, then it should not prevent, it should not treat as a not a precedent. So there are different opinions regarding this type of judgment. Okay, then come to how to understand a judgment. And before that, there is another exception to doctrine of precedent, that is interlocutory orders. Whether interlocutory orders are binding or not. Regarding this, according to one judgment, that is interlocutory, normally, not one judgment, normally interlocutory orders will not binding. But for the purpose of uniformity, for the purpose of consistency, you take 1985 3 SSC 314 Empire Industries. In this case, what the observation of the Supreme Court is that different courts sometimes pass different interim orders as the courts deem fit. It is a matter of common knowledge that the interim orders passed by particular courts on certain considerations are not precedents for other cases which may be on similar facts. This is not a similar case of covered matters. I am not saying about covered matters which are normally seen in high courts. Suppose petitioner is different, facts of the case are same, then interim order is there, then it can be passed. Except to petitioner, there is no other difference. In such cases, it is different, but the purport of this judgment is by citing an interlocutory order which is not finally decided, which can any time can be altered, because suppose interim direction given now, thereafter change of circumstances, it may be vacated. So it is not finally decided the rights, so that it cannot be cited. That is the normal practice. But at the same way, the Supreme Court in Vishnu Traders, in the Vishnu Traders case 1995, Supplement 1, SCC 461. In that case, observed Justice M. Venkatacharya, in the matters of interlocutory orders, principles of binding precedent will not apply. However, the need for consistency of approach and uniformity in the exercise of judicial discretion respecting similar causes and the desirability to eliminate occasions for grievances of discriminatory treatment requires that all similar matters should receive similar treatment, except where factual differences require a different treatment, so that there is assurance of consistency, uniformity, predictability, and certainty of judicial approach. So, for this reason, sometimes interlocutory and interim matters also can be cited as precedent. So, this is regarding interlocutory orders. Then, finally, how to understand the judgment. In Union of India versus Bahadur Singh, 2006, 1 SCC, page number 368. In this case, Supreme Court told that like this, because the exact words are important. Instead of using our language, what is the exact the intention of the Supreme Court is important. Observations of courts are neither to be read as includes theorems nor as provisions of the statute, and that too taken out of their context. So out of context we cannot take the observations of the Supreme Court. Courts should not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. So we have to, when we are applying one decision of the Supreme Court or High Court, what is our duty? We have to discuss how that judgment is applicable in the present case, how it fit in the present case. And these observations must be read in the context in which they appear to have been stated. So context also important. In which context the judgment has been passed. Judgments of courts are not to be construed as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark into lengthy discussions, but the discussion is meant to explain and not to define. So discussion is for explaining, explanation purpose, not to define. So judges interpret statutes. They do not interpret judgments. They interpret words of statutes. Their words are not to be interpreted as statutes. This is some part of some aspects how to read the judgment. So when we are practice as a practicing advocate, or when we are in the position to solve any problem given before us, like law students and other persons, legal stakeholders, we just not to see the head note of a judgment. We have to gone into the, we have to see the entire judgment on which facts this law has been made, whether it is any missing of judgment, or whether it is a per curiam, or is there any ingredients of sub silentio or other facts. Then only we have to cite before the bench. But distinguishing all this depends upon our hard work. So I think it is a good topic for practicing advocates. Thank you.